Welcome and thank you for joining Part 7 of Seyfarth's micro-webinar series, The Future of Work for New England Employers. This installment of the series will focus on OSHA and employee safety for office employees. All participants are in listen-only mode. You are encouraged to submit questions throughout the program through the Q&A section located on the right side of your WebEx window. Any unanswered questions will be followed up by email after the webinar. For those interested in CLE Credit, an attendance verification code will be read during the presentation. Please write this code down. It will not be repeated and is required for CLE Credit. Copies of the webinar recording and materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the program over to Adam Young. Adam, you may begin.
Yes, good afternoon, and thanks so much for having us. I'm Adam Young, a partner here at Seyfarth. I'm here with my colleagues, Patrick Joyce and Melissa Ortega. We're members of the firm's Workplace Safety Group. We're a national group with attorneys in offices around the country, and we work on issues of occupational safety and health, specifically compliance and litigation. Let's go to the next slide. We do have a PowerPoint for you today, but these slides are just intended as guideposts. They are available for you after this webinar. We also have blogs and articles available on almost every health and safety topic. So if you'd like to get our blog on workplace safety, like any articles or any additional information, please feel free to just email one of us and we'd be happy to provide that to you. If anyone has any questions at any time, we want to get those answered. So please type them into the chat, or you can raise them at the end or email them afterwards. We look forward to hearing from you all and what you all want to know and want to get out of this information. So we are here to talk about occupational safety and health law and how it applies to office workers. We used to hear comments that office workers don't face safety and health hazards and the law doesn't apply to them. And I think the COVID-19 pandemic and the mass shootings really opened the eyes of employers to the importance of safety and health as it applies to these employees. So it's a growing issue of enforcement and an issue of importance that we're happy to present on today. I'll turn things over to Melissa.
Thank you, Adam, and thank you everyone for joining us today. I'm going to be talking a little bit about whistleblower retaliation complaints and the hazards that office workers may complain about. Like Adam mentioned, this is a brief overview, so if you have any questions, please drop them in the Q&A and we will answer them either at the end of this program or after. So Brooke, if we can go to the next slide, please. So the claims that can come up for office workers are whistleblower retaliation claims. So these are similar to your EEO retaliation claims, but they arise out of alleged retaliation for raising safety concerns. So what are they? Unlike other employment retaliation claims, whistleblower retaliation complaints are handled by OSHA as opposed to the EEO agencies. So there are various laws that may be implicated in a whistleblower complaint, and a few that can come up for office workers, for example, the Taxpayer First Act. However, today we're just going to be focusing on the Section 11C of the OSHA Act. So under the OSHA Act, an employer may not discharge or retaliate against an employee in any way because the employee initiated any proceeding under or related to the OSHA Act. So under Section 11C of the OSHA Act, this includes raising safety or health-related concerns, asking questions, requesting safety and health-related documents, or reporting work-related illnesses or injuries to the company management or to OSHA directly. So it's important to note that the hazard does not have to actually exist or be present in your office space for an employee to actually be considered to have engaged in protected activity under the Act. The employee simply needs to have a reasonable belief that a violation or a hazard exists. So when can they come up and what are some possible safety concerns that office workers may have? There are a number of hazards that can come up in the office space, and Patrick, my colleague, will talk about them in more detail in just a moment, but some examples can include the use of cleaning chemicals, and like Adam mentioned, we saw this come up during COVID. So there were more concerns regarding cleaning chemicals that came up during COVID, since we were all cleaning a lot. Other concerns could include slip, trip, and fall hazards. So, for example, if your floors are damaged or your carpets, are becoming loose, or you have loose power cords in the office space, since we have so many electronic equipment, and also wet surfaces. Another hazard that can come up is, or complaint that can come up is complaints about poor indoor quality and or heat hazards. So for example, when our air conditioning is not working in your office space, or it just can't keep up with the heat waves that we've been seeing across the country, employees may complain about this. Another, and I think it's a big one, are complaints regarding blocked emergency exits. So it's important to keep those clear. And these are just to name a few. Okay, next we're going to talk about the elements to a whistleblower complaint. So to establish a whistleblower complaint similar to EEO charges, the burden is on the complainant to establish essentially 4 necessary elements. And this is like EEO charges, this is a burden shifting framework. So first, complainants have to engage in protected activity, and that is raise safety-related concerns. Second, the company has to know about the protected activity. Third, the company must take an adverse, or the complainant must establish that the company took an adverse action against the employee because they engaged in that protected activity. However, even if a complainant can establish these 4 elements, the burden then shifts back to the company, the employer, and the company can then refute the elements by offering a legitimate non-discriminatory reason for taking the adverse action. Burden then shifts again to the employee, and the employee must then establish that the offered non-discriminatory reason that the company offered is pretext for retaliation. All right, so filing a complaint is very easy. The agency makes it very easy for employees, and employees can initiate a complaint by submitting a quick form online, by sending an email, by picking up the phone and making a quick call, or by visiting their closest OSHA regional area office. The agency, upon receiving a complaint, then conducts a very cursory screening process. And if it determines that the complaint may have some merit, an OSHA investigator is assigned, and the agency will then send a letter informing the company of the complaint and request a response, typically within 20 days of receipt of the letter. Once a response is submitted, the OSHA investigator may ask for more information, documents, and request interviews of employees. One silver lining is that the statute of limitations, so the time frame by which an employee must file a complaint, is relatively short. It does depend, it varies by act, but it is between 30 to 180 days that an employee must file a complaint. Under Section 11C of the Act, it is 30 days. So an employee must file a complaint within 30 days of the alleged unfavorable employment action. Brooke, if we can please go to the next slide. Thank you. So some best practices to keep in mind when you do receive a complaint regarding any sort of safety issues, we do recommend that you do thank the employee. This will help keep whistleblower complaints at bay. Thank the employee and make them feel like they are heard. Let them know that that safety is a priority for the company and that the company will look into it. A response and priority may vary depending on the severity of the concern, but we do recommend that the company actually look into the complaint that was brought to the company's attention. If the company does look into it and finds a solution, it's important that those follow-up actions are documented and, if possible, that the outcome is shared with the employee who complained. And with that, I'm going to turn it over to Patrick to discuss the common violation for office workplaces.
Excellent. Thank you very much, Melissa. Go ahead and go to the next slide, Brooke, please. As Melissa mentioned, I'm going to talk in some detail about regulations that apply to office-based workplaces. And one of the things we get from a lot of our clients with office-based workers who don't have manufacturing or construction is, well, OSHA doesn't really apply to me, does it? Well, that's not true. And that's what we're here to talk about today. Some of the more onerous regulations, such as lockout, tagout, which you may have heard about, or machine guarding, unless you're actually doing manufacturing in your office. I know some places have laboratories or R&D facilities where that might be an issue. But unless you're doing those types of things, those types of regulations will not apply. But you certainly have other types of regulations that you need to be aware of to make sure you're in compliance with should OSHA show up at your doorstep, either based on a complaint or sometimes they do these random programmed inspections. One of the biggest areas, as Melissa already mentioned, is it's called hazard communication. And essentially what that means is if you have any chemicals in the workplace, for example, your housekeeping or janitorial staff is using chemicals to clean your facilities, they need to be made aware of and given training on hazard communications with respect to those chemicals. And any other employees who might be potentially exposed to those chemicals also needs to be trained and made aware of that. Another big area for office-based employers, as Melissa again mentioned, is slips, trips, and falls. And OSHA calls this, if you hear the terminology, walking working surfaces. That's the name of the regulation that OSHA gave to the regulation. But really what that means is anything that you have to walk on at any point during the day in the workplace. If you can slip, if you can trip, if you can fall, you have to be aware that there's regulations surrounding what has to be in place. So for example, one of the things we see a lot is power cords, and not having power cords stretched all over the place. And it's actually kind of a funny story. We often go to these OSHA area offices to do informal conferences, and most of the time the OSHA office itself has power cords stretched all over the place in the conference room where we are, and we always give them a little bit of a hard time about that. Wet surfaces such as in your kitchens or in your bathrooms, those are some things to keep in mind. Emergency planning, so this is kind of a broader area, talks about fire safety. Most of our office-based employers, clients, don't require their employees, and in fact prohibit their employees from responding to any sort of fire or anything like that using a fire extinguisher. But to the extent you do, they need to be trained on how to properly operate the fire extinguisher, and you have to keep records of those trainings. Even if you don't have them respond, which we typically advise against having employees available to respond unless you're maybe in a rural area or an area where the fire service isn't close by, you still do need to have the fire extinguishers present and have them tested and certified on a yearly basis under the regulations. The other thing that employers in offices deal with a lot is emergency action plans or evacuation plans. What is an employee supposed to do if there's a siren or a fire alarm going off? You have to train them and let them know, okay, you evacuate. Or a lot of our clients are in multi-story buildings, and I know Adam is currently sitting on the 78th floor of the Willis Tower in Chicago. The evacuation plan for Seyfarth is actually just to go down a few floors. It's not to go all the way down to the bottom unless there's a severe enough fire that it requires it. So communicating those types of things to your employees, having evacuation maps, keeping fire exits, like Melissa mentioned, clear, that's a really big area where we see OSHA come in and issue citations. Another thing that office-based employers have to keep in mind is first aid. So OSHA requires you to have a person on site who's capable of giving first aid unless you're close enough to the EMTs or a firehouse that they can get there within 15 minutes. So this is again for our clients who are in remote areas or in high rises. Sometimes that 15 minutes is hard to meet. For example, trying to get up, again, using the Willis Tower as an example, trying to get upstairs into the lobby and then upstairs can sometimes take more than 15 minutes for the EMTs to get there. So you do have to keep that in mind that there is a requirement to have first aid, not only the trained employees, but also have first aid kits available to be able to provide first aid on site. Electrical safety is another big one with respect to having covered outlets, having covered junction boxes, switches, something that you might not necessarily think of as being a problem, but we see it all the time where that's not the case. And finally, the OSHA's general duty clause, which I don't have time to really explain in detail, but this is an area where there aren't specific regulations that apply, but OSHA still comes in and does investigations. We've all heard about ergonomics, having the right keyboard set up, the right screen set up. That's something that OSHA could technically potentially come in and investigate on. And then, as Melissa mentioned, indoor air quality, which became a big issue during the COVID height of the pandemic. Next slide, please. Thanks, Brooke. Another area where we get a lot of questions, this is, again, COVID kind of precipitated a lot of these questions is, well, I'm an office-based employer. Do I have to keep an OSHA 300 log? For those of you who don't know what that is, it's where injuries and illnesses in the workplace are put on the record, put on a piece of paper. Most industries are required to keep these logs, but office-based employers, for the most part, are not required to do so based upon your industry code, which is known as NAICS code. Some office employers do have to, so you really have to pay attention to what industry code you have. We're happy to help you work through that if you need to. However, if you do have the unfortunate scenario where you have an employee either pass away in the workplace, say from a heart attack or from some other condition, and it is deemed to be related to the work they were performing, you do actually have to report that to OSHA under the normal reporting obligations. We bring this up because we have had office-based clients have to do that. They have someone pass away, they have someone get sick at the workplace and it's work related, and they have to actually call OSHA and let them know. Unlike manufacturing, unlike construction, OSHA doesn't usually show up at an office-based workplace. Sometimes they do, but they don't usually. They'll send you their, what they call their rapid response investigation form, where you just answer a bunch of questions, provide them with answers, and they typically, not always again, will close out the investigation. Next slide, please, Brooke. The other area where we get a lot of questions is a lot of our office-based clients have people travel regularly. What happens if an employee is on travel status and they get injured, or if they're at a customer site? Say that you may be an office-based employer, but you have clients or customers that are manufacturing. Well, if they're on travel status and they happen to be injured, then it's possible that something that happens to this employee while they're at the client site or the customer site may have to be called into OSHA if they are hurt while on the site, or if something happens and they pass away. That also is a trigger. Usually it's going to be the host employer, the person whose site they're at, who's going to be calling it in, but sometimes there's a discussion between the customer, the client, and the office-based employer, and they will decide who calls it in. One of the things while you're on travel is once you establish your hotel stay, OSHA has in the regulations that that's your home away from home. And if anything happens while you're at the hotel, that's actually not a trigger. If you're no longer in work status, you've transitioned to your home away from home. That is a good segue into the next topic that I have, and that's work from home. A lot of our employees, as we know, I'm sitting at home working remotely right now. A lot of our clients will say, well, what happens if one of my employees is injured while they're working at home? OSHA really just expects employers to kind of ensure that their employees have the right tools to do their job while they're at home, having the right monitors, having a good setup, providing with training materials on how to sit in an ergonomically way, which I have to remind myself often to sit up. And as a matter of policy, like it says here, OSHA will not come into employees' home if there's an injury or something that arises out of the work that takes place at home. Although it's not prohibited by the law, it's just a policy that they've taken. They don't go to people's homes. If something does happen at home, it's typically not going to be work related or recordable. If it's just, you're at home, you happen to be working, but you go and get lunch and you happen to cut your finger while you're making lunch, that's not going to be something that's work related. But there are some workers who do actual work at home. For example, making new garments. They're doing research and development on garments, and they have a industrial sewing machine at home or something like that, and they get injured doing that work. That could potentially be something, if it results in a hospitalization or something like that, one of the triggers for reporting that you would have to actually report out to OSHA. So there's a lot of nuances that you may not have appreciated until now with respect to performing work at home, traveling, work in the office spaces, that we are more than happy to chat with you about, since we only have a short period of time here. I'm going to kick it over to Adam. Thanks, everyone.
All right, well, thank you. One of the major hazards facing office workers that we deal with in our practice is workplace violence. And we want to talk about what that hazard is and what you should be doing as an employer to address the hazard. If you have employees, you typically have a risk of workplace violence. To be able to address the hazard, you have to understand what it is. And we think of workplace violence through the definition on the left. It's anything that causes injury but would cause a reasonable person to believe he is at risk of injury. So it's based on what the person believes. We need to think about the person who's hearing threats or gestures or comments, and the person who's making those comments. So we should both think of it on both sides. Comments may trigger workplace violence policies and responses, and we'll talk about what those are. But if they fit under this definition where a reasonable person would think they're at risk of injury, we then need to start thinking about those as workplace violence issues. There are many types of workplace violence under this definition, and we see those on the right. It's kind of like a pyramid. Gestures, threats, things they start building up. Active shooter is the most publicly reported type of workplace violence, but that's really just the tip of that pyramid. Issues of sexual harassment and sexual assault can also blur into workplace violence as well. And we know that the two are very highly coordinated and connected. And we see a lot of cases where, the initial warning signs that predicated workplace violence were along the lines of sexual harassment at the workplace. If we go on to the next slide. Workplace violence can also come from different types of actors. And I think a lot of clients just kind of see the active shooter with no connection to the workplace as workplace violence. Really, it's much broader. It can be random, right? Someone that has no connection with the workplace, but it can also be customers or clients. And have concerns been raised about those customers or clients? And we'll talk about that in a second. It could be employee on employee, which is type 3 workplace violence. And then finally, type 4, which I see the most of, is violence against someone at the workplace by someone who has a relationship with that employee. So the most stereotypical context is the ex-boyfriend who shows up at the workplace and engages in workplace violence against an employee. Workplace violence can also occur at the workplace. It can occur outside the workplace. We can hear a lot of complaints about intimidation or bullying or threats that occurred outside the workplace. So something to take into account as well. If we go to the next slide, please. Workplace violence causes a lot of different issues for companies, negative effects. Injuries to employees are the things we're most concerned about, but also disruption, bad publicity. OSHA does regulate workplace violence under its general duty clause, as Patrick talked about. And what OSHA is going to be doing is playing Monday morning quarterback after an incident occurs. They're going to say, was there a recognized hazard of workplace violence in that office space? And did that company take sufficient corrective action to make sure that no workplace violence occurred? So they're going to be asking, well, what was the program? Did they have a written workplace violence program? What information did they have? And were they being proactive in responding to it? If you go to the next slide. Workplace violence and responding to workplace violence is all about proactivity. It's a very highly fact-specific analysis. If you're being proactive to respond to an incident or a threat or a comment, outside of work incidents. Every case is different and many are very different. Comments we've never heard about in any other context come up in every workplace violence incident we respond to and help employers with. We use a systematic matrix approach to evaluate what the risks are and what the possible responses are. And we look at the world through different threat levels based on what actions have taken place, what the pattern is, what's the risk, what threats have been made, or the references to violence, to weapons. And each level has different response options. So really important to do incident assessments. If it's level 2 or above, we got to assemble that workplace violence team. We may need to be escalating to the police. We may need an immediate police response. So if we go on to the next slide, please. Threat notification and make sure we're hearing from employees is important. Having injury reporting, make sure people tell employers that they've suffered some type of injury, and we need to respond to those complaints and conduct investigations as we need to. And workplace violence can occur in the workplace. It can also occur with those traveling employees. One of the most famous OSHA cases about workplace violence is a case called Integra out of Florida, and that's where an employee traveled to different client sites and complained about one of the clients. She said he was flirtatious, he made her uncomfortable, he at one point said Jesus was his father, and the comments all made her a bit uncomfortable. And she came one day and he chased her down the street, 25-year-old girl, and stabbed her to death. And if you look up that company on the internet now, one of the first things you're going to find is an OSHA decision saying that this company did not do enough to protect this woman from the risk of workplace violence. I don't want that to happen to any other 25-year-old woman. I don't want any client or employer out there to that be the thing that everyone finds when they Google you, is workplace violence and that type of risk of workplace violence that you allegedly didn't do enough to prevent. So if you don't have a program now, if you need help with anything, reach out to us. We go to the next slide, please. This is our all contact information on any health and safety question, any question about office or employees. We're happy to provide any help that we can. Did we get any questions, guys, that we could respond to?
Yeah, Adam, I do see one. So it's a question about workplace violence, and I think it's something that you could maybe handle if you can. Do you see any advantages to having trained in-house and on-staff threat assessors to deal with workplace violence issues? Would you advocate for this internal approach to investigate, resolve the issues, or would you outsource these efforts?
Yeah, so I guess in the most lawyerly response ever, it depends. That would be great if you had the ability to have those type of resources on site who knew what they were doing. That's fabulous. A lot of our clients have security department employees who are former FBI, former high-level police who have a lot of expertise in this. Practically, a lot of employers just don't have those kind of resources. And even if you don't have someone who specifically does this, you're going to be making those types of assessments, and we can help you with those. We work with security experts too to try to help make those assessments and come to the right conclusion and the right response based on what we think the threats are. I hope that answers your question.
And then the last thing I think we have, because we're almost out of time, is the CLE code. Do you want me to read it, Adam? I've got it right here since I.
Sure.
So for everybody, I know this is what you've been waiting for, the CLE code. SS, so that's SS as in Seyfarth Shaw, 4172. SS 4172.
Patrick, could you answer the question that was just raised?
I just saw it come up here. Yeah, okay. So the question is, what trends do you see in terms of accountability during an emergency? With many employees working hybrid roles, switching between the office and working at home, curious how other companies are handling taking accountability during an emergency. Yeah, I mean the switch in roles between hybrid and working from home and being in the office, that does certainly complicate things. With respect to training and letting folks know what responsibilities they have when they're at each location, I think that's really what's going to be key. Making sure that when you're at the office, this is something that could happen or you're expected to do if there's an emergency or something like that, or when you're at home. I'll use us as an example. We have a system where if there's a natural disaster, if there's something that's happening and you're working remotely, there's a way to check in to make sure everybody's okay. So just really keeping track and making sure that everybody is well aware of what their particular responsibilities are when that applies to travel as well. I talked about travel. If something happens in an area and you have an employee where they're on travel status in that area where there's been a disaster or an emergency, having very good programs and policies in place to make sure they're safe and check in, that's a good way to do it. So I think we're over time here. Thank you.